Hello everyone, welcome to today's EWCOP Bite-Size seminar, where we're going to try and tell you everything you need to know within quite a short 30-minute slot. This seminar is all about covert medication and best interests, following the recent decision of Mr Justice Poole in the Re-A case. My name is Aisling and I'm a Court of Protection Barrister at King's, and I'm joined by Sam Karim KC, who we're lucky enough to have as the head of our COP team. And I'm also pleased to say that I've had Sam mentoring me since pupillage. But the real bonus for today's purposes is that Sam was actually instructed by the OS on the Re-A case. So thank you very much for joining us. We'll get going. Here's our agenda for the seminar, so you know what to expect. Sam's going to start with the facts of the case. They're pretty complex, not least because proceedings have been running for some time now, and there's actually quite a few reported decisions concerning A. I'll briefly set out the legal principles surrounding covert medication. Sam will explain how Mr Justice Poole applied those principles in this case. Then we'll move on to the legal principles surrounding best interests and specifically the balance sheet approach. And again, Sam will tell us how those principles were applied, and we will finish off with some key takeaways for you. So over to Sam for the facts, please, on the next slide.
Super. Thanks, Aisling. So the facts are quite complex, as Aisling's outlined. There are about 5 reported decisions. So if you're having trouble sleeping during the going to bed at night, then some of the reported decisions are of interesting read. Essentially, just paring it back, P here was a young female adult. She has a diagnosis of mild learning disability, Asperger's, and primary ovarian failure, as I've outlined on that slide. She lacked capacity and continues to lack capacity based on this most recent judgment to make various decisions, including residence care, contact, and in particular, medical treatment. At one given time, a few years ago, at around 2018-17, P and mother abjectly refused the diagnosis of primary ovarian failure, which obviously necessitated medication to allow P to achieve puberty. But later on in the proceedings, mother accepted that diagnosis and the requirement to take medication to improve the situation. The most significant, I think, decision prior to this one was in 2019, where the court decided that P lacked capacity across various decisions and that it was in her best interest to receive medical treatment and that to be achieved covertly. And when I say medical treatment, what I mean is for the primary ovarian failure and for other specific medications for medical treatment, but that's primary or ovarian failure was the main one. Throughout the proceedings and at around 2020, P then achieved puberty, having undertaken that covert medication for a period of time. And the proceedings come up to the most recent decision, where the court then makes the decision as to P's long-term residence and covert medication. And that's against the context of mother making an application for P to be returned home. I should say that the other important issues were that after achieving puberty, it was then considered to be in P's best interest. This is the local authority and the hospital trust position to then receive maintenance medication in the form of HRT. But again, P refused to take that voluntarily. She did some other medications, but not HRT. And so the question then arose as to whether it was in her best interest to be covertly medicated, essentially for life, for HRT, and what impact that had in respect of her long-term residence. So those are the essential facts, and we'll move on to consider the legal framework for covert medication.
Mr Justice Poole pointed out in this judgment that there aren't many authorities actually on the issue of covert medication, which you might find surprising given how often we encounter it. But the judgment effectively takes you through all of the key cases, and I think we could look at each one chronologically. We start with an NHS trust in the patient from 2014. In that case, P was being offered surgery under general anaesthetic for investigation and treatment of cancer. The focus was on P's anticipated reaction upon being told about the surgery. And the judge there decided that it was acceptable for P to be sedated to a degree, first of all, but that it was a mandatory part of the order for P to be informed in clear and sensitive terms about what was going to happen to him in advance. And he said that it was extremely important in any civilised society for a person not to be subject to anaesthesia or invasive surgery without that step being taken. That then led us to the AG case, perhaps the most well-known decision on covert medication, actually, despite it being first instance. In this case, we weren't given a lot of detail about the medication in question, but we know that P had Alzheimer's disease, so we could guess it's perhaps a combination of medication for that and any other physical ailments. District Judge Bellamy made a really good point that a covert medication regime can be a contributory factor, giving rise to a deprivation of liberty, and that, of course, engages a person's Article 5 rights. So in the circumstances, he said that safeguarding by review is essential, and he endorsed a list of procedural guidance that you can find at paragraph 43 of his judgment. So this is the KD decision. In this case, P had diagnosis of schizophrenia and frontal lobe dementia. The court there authorised the administration of antipsychotic medication via an ongoing covert regime. This judgment also looks at the interplay between the MHA, the Mental Health Act, and the Mental Capacity Act, so it is well worth the read if you've got a similar case. Then in 2018, we had a local authority in P, which was a decision from Mr. Justice Baker. Perhaps an unusual one with a slightly different angle because it's about the insertion of a contraceptive device. And we've just had two recently reported decisions, both from Mr. Justice Poole, re-EE and re-CLF. So you might want to compare the analyses there. But here the court had previously in 2012 authorised the insertion of an intrauterine device or coil under general anaesthetic. And then it came back to the court 6 years later for a review. Essentially, the court approved a plan for P to keep the contraceptive device and for her not to be told that she'd had it inserted. The final case we finish off with for covert medication is a judgment from Mrs. Justice Tice. That's worth looking at because it's written with reference to the SMT guidance from Mr. Justice Hayden 2020 and a statement from the Royal College of Psychiatrists on the covert administration of medicine. And that effectively mirrors the case law, but interestingly says that using food for covert medication should only be in exceptional circumstances. So now Sam's going to talk us through the decision on covert medication.
Super, thanks, Ashley. The only two things I would add in relation to the legal background is that, and as Mr. Justice Poole confirmed in this judgment, that covert medication engages Article 5 and 8 of the European Convention. And so when you're looking at whether it's in someone's best interests, you have to decide whether it's justified and proportionate. And there's a couple of decent cases out there, which Ashling's already highlighted, which demonstrate that the greater the interference, the more scrutiny the decision maker needs to be put upon to decide whether it is justified and proportionate. So how that then applies to, in this case, well, the decisions I've summarized are fivefold, which the judge made. He decided that P in these circumstances should return home. The covert medication in respect to the HRT should cease. She should be told that she's been covertly medicated. Mother should be asked to persuade P to take the hormone replacement therapy voluntarily, and that when P returns home, she should be supported by the local authority under their statutory duties under the Care Act. In terms of the justification as to why he reached that decision, he first of all concluded, and this was something which underpinned the entire judgment, that residents can't be divorced from covert medication, i.e. that one of the main reasons why P remained in a placement away from residing with mother with whom she wanted to reside was because of the covert medication. So you can't consider, in his view, residence without considering the nature of covert medication and vice versa. That was against the backdrop of the clinical evidence, which demonstrated that the HRT actually protected P against early loss of bone density, and there was a very significant risk of cardiovascular disease. And as a result of that, he concluded, having heard the evidence, and in the judgment, in particular at paragraph 47, that by stopping the HRT, that could lead to physical disability and premature death, and thereby engaging Articles 2 and 3, which are, as you all know, quite a high threshold, and so quite a stark decision or analysis. But he concluded, and this is quite fundamental, he concluded that he was extremely concerned about the sustainability of the covert medication at the placement or any other future placement which would be away from mother, because he was concerned that P would find out, and if she found out, that would then lead to a disengagement on her part of any services or any future services that the local authority may provide. So he considered that covert medication should be time limited. The other aspects of the decision which are important in terms of justification is that he was also of the view, having heard the evidence, that there was little prospect of P ever voluntarily or overtly taking the HRT in the future. And that's a finding that he made. And that's against the backdrop of the clinical evidence, which, as we said before, HRT is for life, as it were, not the short term. He was of the view also that P could only be persuaded to take the HRT if she was told that she was previously covertly medicated and had possibly achieved puberty, and with the further input from mother to convince her to take it voluntarily. The final two justifications was that he was of the view, also of the view that there was a substantial risk of harm flowing from mother's relationship with P, and it was not possible to negate her influence on P for the foreseeable future. So those are extremely compelling issues and factors which the judge had regard to. But despite some might think some being more weighty than the other, he decided that it was in her best interest not to be covertly medicated for the HRT for the foreseeable future. So we'll go on now to look at the best interest decision that the judge made in this case. But before we do that, we'll do a bit of a recap, or Aisling will, in respect of best interests and best interest analysis.
Thanks, Sam. So we start in the obvious place, perhaps, with sections 1.5 and 1.6 of the MCA. So they really reaffirm that the decisions and acts done under the MCA should be in P's best interest, or must be in P's best interest, and the least restrictive intervention. And then obviously we have section 4, which is the key provision on best interests. But turning to the case law, the starting point is the James decision, and particularly lots of comments made by Lady Hale in her judgment. Mr. Justice Poole refers specifically to paragraph 23, where Lady Hale emphasises that we should look at best interest from P's point of view and look at welfare in the widest sense. And he also points out that Lady Hale recognised that there's limited guidance in section 4 of the MCA about what best interest really means. That then takes us to the judgment of N in a CCG, which is another extremely helpful one from Lady Hale. In that judgment, she is at pains to emphasise that the scope of the COP's decision-making power is limited to decisions that P could take themselves if they had capacity, and she contrasts that with the jurisdiction that the family court might have over a child. And again, she highlights how personal best interest decisions are, and there's a summary there of what she says about it. The case law as well that Mr. Justice Poole refers to has a strong emphasis on what we should do with P's wishes and feelings, because as Sam has set out, that was really significant in this case of Re A. The ITW and Z case was a decision from Mr. Justice Mumby, and there at paragraph 35, he effectively tells us how to take into account P's wishes and feelings in any decision making. The judgment contains guidance on it, and including how to determine what weight should be attached to those wishes and feelings, and it's really useful to transfer into other cases. Then we have Y Valley and V. That's a Peter Jackson case. Builds on the previous case. At paragraphs 10 and 11, we're given guidance again on the proper weight that we should attach to P's wishes and feelings in any particular case, i.e. there is no theoretical limit to that weight. And then there's also that famous line that a lack of capacity is not an off switch for rights and freedoms. So we shouldn't automatically apply a discount to a person's views just because they lack capacity. Now, moving on to the balance sheet approach, I've copied out there a direct quote from Mr. Justice Poole in this case because I think it's important. The balance sheet approach essentially involves taking the factors that are relevant for any particular decision and organising them into the pros and cons. It's something we see a lot, particularly to compare different options for things like residence. The quote there I've included here is when Mr. Justice Poole is identifying the drawbacks of that approach, essentially on the basis that it can be overly simplistic and mean that we overlook the nuances. And on the next slide, I've set out two cases that Mr. Justice Poole effectively refers to underpin that analysis, that when evaluating the balance sheet approach, we need to be very careful with its use. So that takes us then to Mr. Justice Poole's decision on residence and best interests.
Yeah, thank you, Aisling. So, as I said before, given that the judge decided that residence and covert medication were completely connected, and having decided that covert medication was no longer in P's best interest, it then followed upon him to decide residence. And to some degree, that was a bit of a fait accompli, because his view was that one of the main reasons why P was in a placement not living with mother was because of the covert medication. So in turn, she can go home. Now, whilst, as Aisling's highlighted, the most important paragraph in terms of Mr. Justice Poole's analysis of best interests approach and balance sheet approach that should be taken, he adopted more of a let's list the most important issues, and then I'm going to balance them all in the round to make a judgment as to what's in P's best interest. And that's exactly what he did. He didn't have on one side the negative and positives of a particular option, which is sometimes what we see in other decisions. And in fact, what we do on the ground when we're in court, making submissions or coming to a view. He lists the most important issues. And he went on, as I highlighted at paragraph 65 and 73, to list those. And I've covered some of them in terms of the importance of the HRT, in terms of premature death and physical disability, the fact that she, in his view, would never take it voluntarily, and there was a serious harm that she may suffer if she were to inadvertently work out that she'd been covertly medicated in the future. So in terms of further issues, if we just go to the next slide, the court went on to consider mum's relationship with P and made some quite stark determinations in respect of this, considering those factors which are relevant for residence and best interests. And he went on to say that her evidence was evasive when she gave evidence at the hearing. She was reluctant to accept responsibility, lacked realism in terms of P's future care, unrealistic about whether she'd be able to convince her to take the HRT, and that they were in a enmeshed relationship, which was a finding that was made previously in 2017 and 18, and that significantly to date nothing had changed. So those are quite stark findings that were made by the judge in terms of the relationship that between mother and P. And so he went on to consider paragraphs 83, which is the first paragraph I just want to look at, that despite all of those negatives, if I can put it that way, and despite in its submissions, the local authority, the hospital of trust, and the official solicitors taking a different approach and a different view as to P's best interests, he decided that it was in her best interest to go home. And he referred in particular to the decision that Aisling's just referred to of Lady Justice Hale of the End case, where there's reference to, and this is under the second underlining part, which is that there are no such things as care orders for adults, which the Supreme Court was quite keen to highlight. And the second point is that the Court of Protection has to put itself in the shoes of P, as opposed to making an artificial decision on P's behalf. The next slide shows paragraph 84, which is the other significant paragraph in terms of his analysis of best interests. And he concludes that essentially that whilst there are significant concerns on one hand about P being with mother, those in his view are outweighed by the benefits of ending P's deprivation of liberty, because the only reason she was there was by reason of, in his view, the covert medication, and then the serious interference of her Article 8 rights, which obviously arise by being separated from mother, which in particular arose because of the covert medication and other issues. So those are quite stark conclusions in terms of that balancing exercise. But then his conclusion is pretty clear, namely that she goes home principally because the covert medication comes to an end, but also because of the weight that he gives to the interference with Article 8 and adopting the least restrictive approach. And so coming to the end of this bite-sized seminar, we have analysed the decision and tried to come up with some key takeaways. So Aisling, do you want to take the first one?
Yeah, it was just, it just occurred to me how unfortunate the wording of takeaway is when we're this close to dinner time. The first one from me, I think, is this case is going to remind us that covert medication is a really serious issue. I expect that judges will now probably be a bit slower to authorise it than they might have been before. They'll take the lead from Mr. Justice Poole. And I think judges will want very close scrutiny of the purpose, not only of the medication itself, but also of the covert regime. So that might look like having more time-limited orders, reviews built in, and a requirement for transition plans to show how a person might progress towards open medication in future. Sam, what are your thoughts?
Yeah, no, first of all, I entirely agree with that. And I think the principal thing that comes out of this judgment, as you've just said previously, is the time-limited aspect, because there have been, but that's something that hasn't really been considered, in fairness, in the future, in the past, in terms of reported decisions. So that's quite important. In terms of other takeaways, I think that was my phrase, so apologies for that. The first is that balanced treatment requirements and balanced treatment approaches are not always required, and the judge was pretty clear that in most cases it can work when you set out the negatives and positives of a particular option. But in really complex cases such as this, where the issues are really there's a real tension between the issues and they're difficult to reconcile, sometimes you set them out, and that's exactly what he did, and then reached a judgment as to what was in her best interest. Which then go on to, I think, the third highlight, or the third takeaway, which is that the court is the final arbiter of best interests. There's been a lot of reported decisions of past over the last decade that when it comes to capacity, the court is the final arbiter, and experts can say things, professionals on the ground can say things, but actually then when it comes to the hearing, the court, if it can, has a conversation with P and hears the evidence and makes the final decision as to capacity. And that's a similar approach that the judge took here, which is, as I've outlined before, paragraph, I think, 83, going back to the slides, that, he'd made a decision against the submission of all the parties other than Mother. But he made that decision based on what he thought was in P's best interest, putting himself in her shoes. So what I mean by it's not always a fait accompli is that this is a really good decision that you can utilize, I think, in cases where all the evidence is one way, to then demonstrate that, sometimes it doesn't have to be that way, and the court is the final arbiter. And I think the final thing, which is about significant weight that the judge has placed on the least restrictive approach, something that we always talk about. It's obviously enshrined under the Act, but here the court has played significant weight on the least restrictive approach, ending the deprivation of liberty, which he said could be, and fundamentally on P's wishes and feelings. We've had lots of reported decisions as to how much weight, and Aisling's referred to one of them in particular, as to how much weight you should place on P's wishes and feelings based on the level of incapacity, for instance, or consistency of their view. But this is a really important decision establishing that when P's been consistent, you should place significant weight on their wishes and feelings. Aisling, was there anything else that you wanted to cover?
No, we've come in 4 minutes under time, so I think that's our bite-sized goal reached. We have had a couple of questions from some of our people attending the webinar. The first is, can we provide a copy of the slides? I'm sure we can. The second is probably something we can deal with quite briefly. It's about whether this judgment recognises that less intrusive medication might mean a less onerous covert medication regime. So the person who's asked the question said they've got a case where the GP has authorised covert medication for the intake of paracetamol. From what I've read of this judgment, and Sam was obviously immersed in it in a different way, I don't think there is any indication from Mr. Justice Poole that you would have any less scrutiny or any less serious a consideration of a regime if it's paracetamol compared to anaesthesia for cancer surgery. But I hear what you say, that they are quite different considerations. What do you think, Sam?
Yeah, I mean, I suppose the starting point, I mean, I entirely agree. I think the starting point is what P's wishes and feelings are. I mean, if they are that I'm happy to take it, then obviously you're not considering covert medication. But if they are consistently saying that they don't want to take it, then it's an interference. And I agree that if it's an interference, then you got to look at whether it's justified and proportionate. And so it's still important to go through those steps to decide whether it's required. So I agree. I think we had two other questions that were provided before this seminar. I think the first one was in respect of power of attorneys and whether what their role could be in authorising or approving is probably the right phrase to use covert medication regimes. And what I took from that question was that if you've got perhaps a property and affairs or in particular health and welfare deputy, could they authorise or could they approve a covert medication regime? And my take on that is that I don't think they can. It's quite a significant interference, especially if P is resisting and is consistent in that resistance. And so you probably need to get court authorization as opposed to approving that. What do you think, Ashley?
Yeah, I think exactly the same. And we've also had a question about, for example, a depot injection for antipsychotic medication. I think those sort of obvious forms of medication are going to be very difficult to administer covertly. I certainly, when I've had experience of injections in my cases in the past, there's never been a proposal that they could be administered without P's consent, and sometimes that's to P's detriment for obvious reasons. I can imagine that there might be some cases where you could work out a covert regime, perhaps if P doesn't know what's in the injection, but I would suspect that anybody who's had antipsychotic depot injections in the past probably knows what's coming in the future. So there might need to be alternative ways of managing that, and it's unlikely to be with a covert medication regime.
Yeah, that sounds about right. I think we're probably under the lines of sedation or possible restraint as opposed to covert medication.
Yeah, I think so too.
Which obviously amounts to a dole, so that need to be authorised in some way.
I think that takes us to just 1 minute to go. We've had another couple of questions in the chat, so perhaps if you turn to the last slide, those are our email addresses. So you can always email us with any further queries. We know there's quite a lot of food for thought in this judgment. But overall, just to say thank you particularly to Kim, who is queen of our marketing team and has done the PowerPoint for us, but also thank you to you all for joining.